Thank you very much, Mr. Chairman. I want to thank you for having the hearing because I think it's an important topic, and I would like to join with Ms. Tobias's recommendation that we have a hearing on my bill, which is the Pain-Capable Unborn Child Protection Act 1670, and have a joint vote on the Senate floor and see where everybody falls out on it, because it's a subject worthy of debate. Let's see if we can find some common ground here about how all these laws work. Ms. Tobias, is it your understanding that 1670 would prevent a ban on third trimester abortions that protect, with exceptions for the life of the mother and rape and incest?
1670? Yes.
Excuse me, the other one, 1696.
The one today?
Yes, ma'am.
Okay.
I'm sorry.
Yes, this bill would would prevent a ban on abortion in the last trimester. It would prevent...
Ms. Northup, do you agree with that?
The bill has provisions that track the constitutional standard that do say that post-viability, there needs to be an exception for a woman's life and health, as the Supreme Court has said.
So could a state pass a law that banned abortion in the last trimester except for life of the mother and rape and incest? Your answer would be no?
The standard would have to be that the Supreme Court has recognized.
What do you say, Ms. Tobias?
Well, I think probably one of the best examples would be when the sponsor of the bill, Chairman Blumenthal, was asked if this bill would ban abortions. It talks about life or health, and he said that the health would make no distinction, the exception makes no distinction between physical or psychological health. So it would be very difficult, it would be impossible under this bill to ban abortions for health if psychology and psychological health is going to be
There are 13 states. Thank you. There are 13 states that ban elective abortions after 20 weeks, except in the case of rape and incest in the life of the mother. Would this bill strike those laws down?
Yes, it would.
Do you agree with that, Ms. Northup?
Like the Ninth Circuit did with Arizona's 20-week ban, yes, it would be unconstitutional, and this bill tracks the U.S. Constitution standards.
States that have waiting periods, requiring a waiting period before the abortion is performed, would this bill strike that down?
Yes, this bill would say that if you impede access to abortion in any way, it would be struck down.
Ms. Tobias, do you agree with that?
I don't. It depends on what the court would look at. So again, as we were talking before.
So you don't know how the bill works?
Yes, yes, I do. It's that the first question would be, is this type of waiting period something that is also imposed
the ones that are on
similar...
the books, the ones that you're familiar with, can you name one state law with a waiting period that you think would survive?
Well, I would say that I think it's important that we look at the factors in the bill. Does it apply to similar services?
Can you name one state with a waiting period requirement that you think would survive scrutiny under this bill?
Well, if it were able to say that it did not significantly impede access to services, if it was a waiting period that is not a particularly long one.
You can't give me an example. Ms. Tobias, does this bill ban states' requirements that a person can exercise their conscience and opt out of performing an abortion? There are laws on the books that say that, right?
Yes. If someone says that, according to their conscience, they cannot take the life of an unborn child, that would be impeding or reducing access to abortion, which would not be which would be invalid.
Would this legislation invalidate those laws?
Yes, it would.
Do you agree with that, Ms. Northup?
I don't agree. This legislation doesn't address the issue of conscience objection.
Should it? Would you accept an amendment offered by me to make sure people of conscience don't have to do something like this?
Well, I think we have important laws that are on the books that respect people's rights of conscience.
Well, as to this issue, would you accept an amendment by me to this bill to exempt conscience?
Well, I'm not elected to make those decisions. I think this bill clearly doesn't cover that.
Fair enough. I think the answer would be no. So, Dr. Parker, is it standard medical practice for physicians operating on a child at 20 weeks to provide anesthesia to that child?
Well, Senator, I'm not well versed in fetal surgery because most surgeries at 20 weeks would have to occur in utero.
Yeah, well, right, they would. Ms. Sherrill, is that Are you familiar with what would be the standard of care there?
Yes, it is, and that's because when fetal surgery is done, and I'm very well aware of the fetal surgery landscape, initially when fetal surgery was being done, fetuses reacted very strongly to incisions, to placement of catheters.
So standard medical practice to provide anesthesia when you operate
Yes.
on a baby at 20 weeks.
Yes.
Medical encyclopedias, and I'm sorry I'm running over, I'll wrap it up here, encourage parents to talk to the baby at 20 weeks. They can hear sounds, they react to your voice, they can hear your heartbeat as a mother, they can hear your stomach growling, and they can react to loud noises. Does that make sense to you, Ms. Schroe?
Yes, it does.
Okay. Has anyone ever been born at 20 weeks that survived?
As far as I'm aware, no.
Not to my knowledge.
I can show you twins. Thanks.